All right, hey Spanish Springs, welcome back from spring break 2013. I hope you had a nice little break, got some sleep, some sun, something nice as we make this last push towards the AP exam on May 14th. All right, so you can prove your high efficacy levels. All right, so today I'm going to talk about 17 through 22, which is day 4 for the regular classes. Day 5, I think, for zero period. I'm going to review 17 and 18, which we did this morning, all right, pretty quickly, and then get into the rest of this stuff. All right, so today we really get into life, liberty, property, and the due process of law. We bumped into due process clauses for the concept of incorporation with Barron v. Baltimore and Gitlow versus New York, all right? But now we kind of talk about what the heck due process is, all right? But first, let's do a property here really quickly. There's this concept called eminent domain, which is in the Constitution's 5th Amendment, which basically says that private property shall not be taken without just compensation, all right? And the private property has to be taken for what's considered public use. Now, that public use is probably pretty questionable. That can be for highways that need to be built through certain places, roads that need to be built through certain places, you know, dams, bridges, military bases, airport runways maybe need to be extended. Generally, public use generally falls in the category of that kind of public use. Now, in the Constitution, this concept of eminent domain, in which the federal or state governments can take private property, they have to give just compensation, which essentially means, you know, market value for a home. Now, I'm probably, or I'm pretty sure that maybe that what market value is going to be debatable between the people that are buying the land, the government, and the people that are going to be forced to sell the land, which is the private citizens. So that in itself could be controversial. All right, but again, public use, the federal government at times will invoke this idea of eminent domain, which means they can take private property for public use as long as they give just compensation. Now, the Kilo versus New London case, which is in the notes, talked about where you had some land sitting kind of dormant. A private owner was doing nothing with the land, and a city used eminent domain to take that private land that wasn't being used and turned it over to a private contractor for economic development, you know, a mall, restaurants, something like that. Their economic development, a manufacturing area, something like that, all right? And that's a little bit more controversial. Now, in 2005, in the New London case, the court upheld that definition of public use because there was economic growth, which I'm assuming is incredibly controversial because, you know, private property is one of the foundations of American republic, and so I'm assuming that that New London case was incredibly controversial. All right? So eminent domain, just compensation, and public use are the keys there with property. All right? And now let's jump into this idea of due process. All right? Like we said earlier, we jumped into the due process clauses of the 5th and the 14th Amendment. All right? When we bumped into the Gitlow and the Barron's case. All right? And then the subsequent cases that federalized or incorporated different rights in the Bill of Rights to the actions of a state government. The selective incorporation. So there's 2 types of due process. There's substantive and there's procedural due process rights. So what procedural due process is it means that if the government is going to deny you life, liberty, and property, and again, both state and national, that they must follow a correct procedure. The way in which they deny you life, liberty, and property must be fair. The steps that they take. So if they're going to arrest you and throw you in jail, they've got to have a lawyer for you. They've got to have a trial for you, a jury trial, the right to confront your witnesses, the right to a lawyer themselves. No violation of your Habeas Corpus rights. Those kind of things, which we'll get into in a minute. But this idea in which the manner or process in which they deny you life, liberty, or property must be fair. So usually when you think of due process right, or procedural due process, you think of the steps taken to deny you life, liberty, and property must be fair. All right? Now, the other kind of due process is substantive due process. And substantive due process, the question that you ask is, the law that is written, so a law that bans all Dodgers gear, sorry, Mr. Wershing, from being worn in Spanish Springs High School. And what you say is that the outcome of that law just? Or is the outcome of that law unjust or unfair? And if it's unfair or unjust, the law itself, it violates your substantive due process rights. So the difference is when you're looking at substantive due process, all you're looking at is the law, is the ordinance, is the rule and regulation fair? Is the outcome of that fair? And then procedural, you're looking at the steps taken to deny you life, liberty, and property. Are they fair? And that's procedural due process rights. So if you look on page 18 of the notes, you have a couple things. So if you say, the police conduct a strip search. Now, whether or not those are a violation of your due process rights or not, it probably depends upon context and all this. But because you're looking at an action that they take, you'd be thinking about procedural due process rights. Now, a law that mandates or requires that all kids through a certain level get a certain amount of vaccinations. So now we're looking at the law, right? The law that requires compulsory or mandatory vaccination. Is the outcome just or unjust? And in this case, because you're looking at a law, you're going to say it's substantive due process. Now, a minimum wage law. Again, the key right there is whether or not you believe minimum wage laws are good or bad is kind of irrelevant for our discussion. But what we're looking at is it's a law, and is the outcome of that law just or unjust? And so you're looking at a substantive due process issue. And then finally, firing an employee without giving a hearing, a government employee without a hearing. So again, if they deny you that job and they don't do it in a fair manner, then it would be a procedural due process right. All right? Okay. So unfair court procedures are violations of procedural due process rights. Illegal searches are a violation of procedural due process rights. All right? So again, procedural and substantive due process. The key is when you're looking at substantive, you're looking at is the outcome of the law just, the final outcome. Would it be just if somebody got that punishment or whatever the law said would happen? And the procedural is the way in which, the process in which they deny you life, liberty, and property fair or unfair. And that would be procedural, all right? Okay, so let's kind of look at, and I think like 19 through 22 link a lot to procedural due process rights. If you look at page 19, this is zero, this is the new stuff for you today, all right? Page 19 talks first and foremost about arrests or seizures and illegal searches and illegal seizures, all right? The Fourth Amendment protects you against illegal searches and seizures, all right? So seizure would be an illegal arrest. An illegal search is an illegal search, which we'll get into, all right? And so arrests are legal if they have a warrant and there's probable cause to arrest you. And in hot pursuit or when probable cause exists, if you're committing a crime, they don't need a warrant. They can arrest you if they've caught you in conduct of engaging in a crime of some kind, all right? Now, searches are the real big deal, all right? And, hey, by the way, let's do this really quickly. Arrests or seizures, we can link to Habeas Corpus, which is on page 20, all right? And Habeas Corpus says that if you arrest somebody, you cannot illegally detain them, which means is you have to present some evidence and charge them with a crime or release them. So Habeas Corpus protects the government from saying, okay, we think you're a bad person, we're going to throw you in jail, we don't have any evidence right now, we can't charge you with a crime because we don't have enough evidence to go to trial, but we're going to keep you there because we know you're up to no good. All right, so that's a procedural due process right, all right? And we'll get more into Habeas Corpus in a minute. Now, searches. Searches can be conducted when probable cause exists, all right? Now, a warrant usually, a search warrant has to be specific. It usually has to say, you know, what are we searching for and where are we searching for it, all right? Now, what happens is the law enforcement officials will go to a judge to get a warrant and kind of outline their argument. This is why we need a warrant to search this place, this person's home, this person's, you know, storage unit or something like that, right? And then the judge, upon hearing that, will say, okay, you have enough evidence, you should definitely search it, or you have enough just to go search, right? And again, procedural due process. They can't search unless they follow those procedural due process protocol or steps. Now, the reason that our Constitution has this kind of high demand for searches, and especially search warrants, is because the British when they occupied America in colonial times, had things called writs of assistance. And these writs of assistance essentially allowed the British authorities to go anywhere at any point that they wanted to search things for anything. Right? And our framers believed that that was too broad and gave too much power and took away too much freedom from individual citizens. Too much power to the federal government or state government or city government, and took too many rights away or freedoms away from individuals. So hence we have the Fourth Amendment. All right? Now, they can search without a warrant in a couple examples. There's the automobile exception. So if you're swerving around the road and they think maybe there's alcohol in the car, that kind of thing, they can search. All right? If they believe you're armed and dangerous, they can search. When they're making an arrest, they can search you as they're legally arresting you. All right? If the evidence is also in plain view. So if a police officer pulls you over for a speeding ticket and in the back you have a dead body and it's in plain view, they don't need a warrant to get in there and look at that dead body. It's in plain view, they have it. All right? Now, we get into some other things. Wiretapping. Wiretapping is essentially a search. Looking into phone records, listening into phone conversations, emails, texts, all this new kind of stuff as well with the emails and the texts. All right. And again, usually what the government or the authorities need is some kind of warrant to do that search. All right. Now, there is the exclusionary rule. All right. The exclusionary rule, which was established in a case called Mapp v. Ohio, said illegally obtained evidence cannot be used in a court of law against a suspect. All right? Now, that was Mapp v. Ohio for state cases. Weeks versus U.S. took that same exclusionary rule and applied it to the actions of federal cases. All right? Now, one of the arguments against the exclusionary rule is that bad guys get off on technicalities because a warrant wasn't carried out perfectly and correctly, and therefore the evidence can't be used. Even though it was evidence that clearly linked this person to this crime, they can walk off on a technicality. The other side to that is that police officers, law enforcement officials from the federal all the way to the city level, it discourages misconduct because they're going to get the evidence correctly. They're going to get confessions correctly. People are going to have lawyers around, and they're going to follow procedural due process before they deny you life, liberty, and property. And that way, it discourages police misconduct. All right? Now, those are the two sides to it. Now, again, the exclusionary rule does not apply if there is an inevitable discovery of the evidence, which means that they have a warrant to check your basement, for illegal weapons that are happening, and they walk down a hall and these doors are wide open and there's drugs and there's a counterfeiting machine and there's a dead body. They don't need a warrant if they would have inevitably discovered that stuff along the way when carrying out that warrant. All right? And the good faith assumption that a law enforcement official is carrying out that search warrant faithfully and then steps over a dead body or, happens to look left and sees through the crack in a window there, that, there's more illegal evidence against you. All right? They can use that. All right? Okay. Now, I think one of the things I'll just talk quickly about the Patriot Act is the Patriot Act dramatically, following 9/11, enhanced the federal government's powers for searches. For searches because they're trying to get, after 9/11, they're trying to make sure that that never happened again. And so, it gave them greater power to wiretap phones, to monitor email, to survey financial records, or conduct searches, okay? It basically it also gave them the power to deport or detain non-citizens without a whole bunch of procedural due process rights, right? And in essence, it strengthened the power of the federal government. But again, you always have to apply the balancing test to your rights, liberties, all right? They're not absolute. This idea of we're balancing freedom versus order. And in that moment, following 9/11, the Patriot Act was passed pretty, not unanimously, but definitely passed easily to give the federal government the ability, and state governments, the ability to find bad guys before they carry out things like the 9/11 attacks. All right, now we'll bump into the Fifth Amendment. The Fifth Amendment is chock full of stuff. I know we talked about the Due Process Clause. We just talked about eminent domain. It also protects you against self-incrimination, which essentially is you don't have to testify against yourself in court if you don't want to. All right, because the idea is you're innocent until proven guilty. All right, so they need to bring the case against you from other witnesses. You do not have to testify. All right. Fifth Amendment, chock full. Now, let's get into the next case, which is Miranda. So we had Weeks versus U.S. and Mapp v. Ohio, which were both about the exclusionary rule, all right? Now, Miranda versus Arizona, basically, which I know you guys know. You've seen it in the movies and TV, whatever. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you don't have an attorney, one will be appointed for you. Miranda basically said that arresting officers, arresting officials, had to kind of tell you your rights when you were being arrested, so you were aware of your rights. All right? Okay. Now, three old friends: habeas corpus, ex post facto, and bills of attainder. Basically, bills of attainder are a law that punishes you without a trial. That absolutely violates, well, think about that, a law or act that punishes you without trial. There's substantive due process. And I would also, you could argue, well, I guess you would say substantive due process in that case, right? Okay. And they may not be passed by Congress. These are denied to our government in the Constitution. No bills of attainder. The same with ex post facto law. And again, ex post facto is just retroactive punishment. If you did something on Tuesday and it wasn't illegal, but on Wednesday they made that action illegal, they can't go back and punish you for what you did on Tuesday. Right? And again, this was thrown into the Constitution as kind of an experience that our framers had seen with the British government going back and saying, okay, we don't like what these people are doing, let's make it illegal and then retroactively punish them for doing that. All right? Now, again, habeas corpus. The idea is if you are arrested, you will have to be brought in front of a court or a judge, and then they are going to have to charge you with a crime. All right? And if they don't have the evidence to charge you with the crime, they have to release you. And again, some of you guys that have police officers for family relatives, maybe you can get this, but I know it's so many hours before, if they don't actually charge you with a crime, they have to release you. Now, think about that. That prevents you from being illegally obtained for months and months and months and not getting a trial, not getting a lawyer, that kind of thing. All right? A lot of the people that were held in Guantanamo Bay that we call terrorists claimed that their habeas corpus rights were being violated because they weren't being charged and they weren't being given legal assistance. All right? So, and again, habeas corpus can be suspended in times of rebellion or invasion. We saw that in the Civil War by Lincoln. All right, I think there is a little bit of controversy of it's given to Congress as a power, but we've generally seen presidents suspend it. All right, and think about this: if they do charge you with a crime, then immediately your procedural due process rights kick in. Habeas corpus is that. Think about if you were arrested, you get your Miranda rights, which are your rights are read to you. Right? And then you have habeas corpus, in which they have to charge you with the crime or release you. Because if they do formally charge you with the crime, then the rest of your procedural due process rights kicks in. You get a lawyer, you get a jury trial, a speedy trial. You get the right to confront the witnesses and claim, cross-examine the evidence they have, and all those kind of procedural due process rights that we see accused people have. And again, the idea is these rights are not there to protect the guilty, they're there to protect the innocent, because people can be unjustly charged with a crime. All right? Okay, so habeas corpus, ex post facto, bill of attainder. All right, now let's move on to 21 and 22. All right? 21 is the rights of an accused. All right? You have the right to a counsel, which means you have the right to a lawyer. Now, Gideon v. Wainwright said that states must provide legal help for you if you can't afford one. And that was 1963. So prior to that, if you couldn't afford a lawyer, you didn't have a lawyer. All right, but that's the right to counsel, Gideon v. Wainwright. Thank you. I'll talk to Garrick. Thanks for the t-shirts, though. All right, and then Johnson v. Zerbst applies this to the federal government, that if you are charged with a federal crime and can't afford a lawyer, you will be given a lawyer to defend you. These people are usually the public defenders, the public defender's office, all right? Okay. Now, you also have rights of accused, the right to counsel. You have the right to a protection against excessive bail. So the idea in the 8th Amendment, it protects you against cruel and unusual punishment and excessive bail. Right? So generally, what that means is the bail, to let you out on bail before you go to court, rather than being detained the whole time, is the bail amount must match kind of the crime. So if somebody, steals a candy bar, they can't have $1 million bail. All right? Now, I think that, I'm not quite sure what the bail was for the Breonna Dennison killer, but that was one that was very high because the crime was incredibly, horrific, and therefore the bail was high. So it wouldn't be determined to be excessive bail. All right? Now, the gravity of the offense needs to match the bail. All right? And again, not everybody gets bail. All right? If they think that you're a flight risk, if they think maybe you would commit suicide or go commit more crimes, that kind of thing, they don't have to give you bail. All right? Now, the next thing, you have the right to a speedy and public trial. Right? Which means speedy, which means quick as possible, and two, it means public, so it's not these secret courts that we've seen in totalitarian regimes. All right. You also have a grand jury right, which basically, remember a grand jury? We talked about the grand jury and the petite. A grand jury simply says they determine if there's enough evidence to take you to trial to see if you're guilty. A petite jury says guilty or innocent. A grand jury says, is there enough evidence to take you to trial? Now, you only have that protection of a grand jury trial, a grand jury indictment at the federal level. It has not been federalized, nationalized, or incorporated to the state level at this point, all right? Now again, not only do you have the right to a speedy and public trial, but you have the right to a trial by jury, which means, again, you can be judged by your peers in your community, all right? Witnesses, you have the right to bring witnesses on your behalf. You also have the right to cross-examine or challenge the witnesses that the other side brings to the table, all right? Now, the other thing is, all right, cruel and unusual punishment. The Eighth Amendment protects against cruel and unusual punishment, all right, banned by the Eighth Amendment. So again, the punishment must be proportionate to the crime, all right? The death penalty at this point has not been ruled cruel and unusual, all right? Now, and if you have any more questions about the death penalty cases, we can talk about those in class, all right? Eighth Amendment, cruel and unusual, excessive bail. All right, and then finally, we get into the double jeopardy, which is, again, fifth. All right, and the Fifth Amendment protects you against double jeopardy, which means if a court declares you innocent, they cannot retry you for the same crime again. Now, what happens is, if you commit a crime that is both a state and federal crime, they can find you innocent in the federal court, but still try you in the state court. Now, if they find you innocent in both the federal and the state, they can't charge you with that crime again. You've been declared innocent of that specific crime. All right? And again, I think they can't do it if there's a mistrial. They can have a retrial if there is a mistrial, all right? But the idea, again, is to protect, you from the government just saying, I don't like you, we're going to get you on this charge and get you in jail if it takes us 5, 6, 7 tries. That's what the double jeopardy protects you against, all right? Okay. Yeah, that's it, y'all. So if you have questions, we'll talk in class. Now, the other thing is zero period. I would look at which case talked about flag burning, which case talked about, these are all speech, which case talked about wearing black armbands as a form of symbolic speech, which test said that speech can be suppressed if there's an imminent threat. What did Gitlow v. New York say? What are the 2 religious clauses in the Constitution? What amendment says, what does the 9th Amendment say? All right, and then what established the right to privacy? Those are all extra credit tomorrow morning, all right? All right, have a good day, you guys. Ciao.